Okay, class, how you doing?
Good. How about you?
What was that?
I said, how about you?
I'm doing all right. Hey, I'm glad y'all guys are doing pretty good. Today, you know what we're going to talk about? Anybody know?
Civics.
Obviously.
Hey, look, you
What
always talk about
we're going to talk about?
It's like
the federal court system.
Federal court system. We're talking about the federal court system. That's what we're going to talk about today. Okay. Anybody know why the federal court system is important? Like, what happens in the courtroom? Like?
Justice is served.
Justice is served, right? And in the court system, that's what we handle. What we have,
Politics.
Disputes, right? Right. We have disputes, arguments, right? There's no fights and nothing going on, right? Not no literally fist to fist fights. It's more just casual debate about issues, right? About issues that are important. Like, anybody know some big time famous Supreme Court cases? Like
Money. The black.
Brown versus.
That
Come on, sorry.
city.
The Board of
Education.
and Topeka, Kansas, right? Anybody know why that case was important?
Because he killed a black man was killed that day for no reason other. Well, what did they say?
I don't know what they talking about.
segregation for schools not allowed.
Correct. It made segregation. It ended segregation in public schools. That's why it reversed the famous case from I think it was 1894. Plessy versus what? Plessy versus Ferguson. Exactly. No, Ferguson. Okay. Now, I want y'all to pay close attention, like, we're going to be watching a video today. And on this video, you know, I'm going to let you know you're going to be taking a quiz at the end of the class. But it's important that you watch the video. If you watch the video, you should be able to do well on this quiz. Because we're going to have a few questions, maybe a majority of questions from that video. But beforehand, I want to make sure I go over a few facts with you, so you'll know. Some of these facts could be on the quiz, you never know. Anybody know how many circuits there are?
Circles?
Circuits, like traditional courts. Are they 3, 6, 9, or 12? Anybody know? 12. 12 is the correct answer. There are 12 traditional circuit courts. Okay? And in these courts, these are the courts where disputes are handled. And before a case can reach the Supreme Court, it must be handled where?
The lower court.
In the lower courts, which would be like your circuit courts and your
state courts.
And your state courts. So it's very important that a case is handled at the lower level before it goes to the Supreme Court. When the case makes it to the Supreme Court, it's at the what? It's at the end of the what?
Road.
It's at the end of the road. It's all or nothing at that point. Once it gets to the Supreme Court, there ain't no other court it's going to go to. It's reached its max potential.
It could go back down.
If it goes back down, it's because the Supreme Court has kicked it back down to them. Because sometimes the Supreme Court don't want to handle cases. Anybody know why the Supreme Court don't want to handle some cases?
Because they'd be stupid cases.
No, not
They don't want them to get mad.
They don't want people to get mad. And what is some cases that are kind of controversial? Like, there's a case that
the case where the man was he got shot over some Skittles and Skittles.
That's a child case. I'm talking about like more of like a court decision case. Like, anybody ever heard the case of Roe v. Wade? Roe v. Wade. Anybody remember that? Ever heard that case? No. Anybody? Y'all know what abortion is?
Abortion? Do you give it to your child?
No.
That's abortion.
Okay. Now, in the case of Roe v. Wade, the court ruled that a woman has the right to abort a child if she so chooses. Now, that is a heart-wrenching case because it really gets people. It's very emotional. It's very deep, and it's very political also. You know, you hear about it like I think I hear about it every election cycle. You got the Democrats there pro-choice, pro the woman's choice, and you have Republicans there or against abortion, period. A lot of them are against it in any circumstance. However, there's a lot of gray areas and issues too. And the courts kind of help settle all this. They kind of bridge the divide, if you will. And they pretty much settle those disputes. And I want y'all to pay close attention to this video, because we're going to talk about some cases. So, pay close attention, okay? We're going to do a little activity afterwards.
PBS did a crash course government and politics, and today, finally, we are stepping into the big leagues. That's right, I'm trying out for the Cubs. No, we're going to talk about how the Supreme Court of the United States actually works. I could try it for the Cubs, right, Sam? Sometimes people refer to it by the unfortunate nickname SCOTUS, but I'm not going to do it. I'm going to call it the Supreme Coco, or Coco Supreme. Now, let's just be respectful. So strap in and get ready for some highly technical discussion of procedure as we learn how you, yes you, probably not you, can bring a case to the Supreme Court. The first thing we need to take a case to the Supreme Court is a case, or controversy. And except in certain rare situations where the court has original jurisdiction, that case has to have already been heard and decided by a lower court and appealed. And not just once. Before a case gets to the Supreme Court, you have to have exhausted your appeals at lower levels of the state or federal system. If you've lost your previous appeals but still think that you have an issue worthy of the court's attention, you can petition for a writ of certiorari, which people in the know call the cert, because they're keeping it cash, which is short for casual. For a look at how the court chooses cases, let's go to the thought bubble, or the thubub. A lot of nicknames today, Stan, or SP. Certiorari is a formal request that the Supreme Court hear your case, but petitioning for a writ is no guarantee of anything. The federal government's chief lawyer, the Solicitor General, is basically like a bouncer at a hot club, if you're old enough to get into a hot club. They screen out a lot of petitions because those cases don't raise a lot of federal law questions, or because they've already been decided in other cases. Or they're not wearing good enough shoes to get in the club. If, and it's a big if, your petition is granted, it goes into the cert pool, the first round in which the justices decide which cases they're actually going to decide. The list of cases that will be decided is called the discussion list. For the judges to actually hear the case, called granting certiorari, 4 of the 9 justices have to agree to hear it. This is called the rule of 4.
I want y'all to make sure y'all try
To actually hear the case, called granting certiorari, 4 of the 9 justices have to agree to hear it. This is called the rule of 4.
I just paused that in time. Oh, y'all write that down. That's pretty important. That is pretty important right there. So you don't even need a majority to hear a case, do you? No. All you need is what?
Just 9 of the 4 people in the Supreme Court. Just
4 of the 9, right? All you need is 4 of the 9 of the justices. So you don't even need like 5 justices, which is that's how they rule on cases. They rule by some majority of 5 to 4. But all you need to hear a case is just 4 out of 9. So that's pretty good right there. That allows people who may be in a minority to at least get their case heard, even though it won't be ruled on or ruled in their favor. They can at least bring up the case. Because it's usually not hard to get 4 people. Anybody know what's the political views of the court today? Is it conservative or liberal?
No.
No, it's not.
It's conservative.
It's
Whatever she
conservative.
didn't say.
It's conservative. There are 5 conservatives on the court. There are 4 liberals on the court right now. Of course, we're about to have a few that's going to retire in a few years because they're getting on up there in age. So they're about to retire in a few years. Okay.
No, I'm not ready.
Now some of these I'm gonna stop, and then some of these I'm just gonna let the video go and just go on the road. But some of these I really want to make sure that y'all understand and that y'all get down because I feel like they're very important. And if I stop the video, that tells you what?
Right.
Yeah, you probably want to write that down if I'm stopping the video. If I don't stop the video, it's probably important, but not as important as the ones I stop.
Still not ready.
Take advantage of when I stop the video. You know. I don't have to, but I want y'all to learn it. I really do want y'all to know what that is. Everybody got it now?
No. You can fuck it up, but it's not fucking up. Touchdown.
Anybody else feel right? We got 10-10.
The discussion of the discussion list and decision about whether or not to grant certiorari happens at the conference, which is like the back of the club where the really well-dressed people go. So the judges have read your petition, and 4 of them have decided that your case is one of about 80 that they will hear. Congratulations! Now you and the side that disagrees with your position have to submit briefs. Briefs are not underwear. Briefs are written legal arguments from each side explaining why the law favors their position. The party bringing the case seeking to overturn the lower court decision is the petitioner. The party that wants the court to uphold or affirm the lower court's decision is called the respondent. The petitioner also files a reply, which attempts to rebut the respondent, which is not a euphemism. After filing all this, you're finally on your way out of the thought bubble. You're on your way to court. Thanks, the bub. You might think that there would only be 2 briefs in a case, one from each side, and it's true that there must be at least 2. But often there are many, many more briefs, and even boxer briefs. That's what Stan wears. Stan, put your pants on. All undergarments aside, individuals or groups who are not actually parties to the case but have an interest in the outcome can also file amicus curiae, or friend of the court briefs. Amicus briefs often contain different legal, economic, or historical arguments that can sometimes persuade justices and appear in their opinions. They're also one way that interest groups can attempt to influence the Supreme Court. After the briefs have been filed, the court schedules oral arguments, giving them time to read and consider the briefs. Each side gets half an hour to make its case, but this time includes questions from the justices, so most of the time is usually spent answering questions. Imagine a presentation with the most intense teacher you've ever had bombarding you with questions, except that there are 9 teachers. Well, 8, because Clarence Thomas never speaks. After oral arguments, you wait for a decision. The justices then meet in another conference, which is held on a Wednesday or a Friday, because there's good TV the other days. In order for the court to render an official decision, 5 of the 9 justices, a majority, must agree on at least one of the legal arguments that either affirms or overturns the lower court's decision.
Oh.
Yeah, it says, in order for the court to render an official decision, 5 of the 9 justices, a majority, must agree on at least one of the legal arguments that either affirms or overturns the lower court's decision. That is very important. Because 5 out of 9 is just a simple majority. Okay? That's when they rule on the case. Because somebody's got to win and somebody's got to lose. So, in most cases, do end up going 5-4 these days because the court is divided along political lines. But every now and then there are some cases that are set precedent. In those cases, you usually have like up to 7 or 8 or 9 justices all agreeing to set a precedent for that issue. Okay. That's good. Who's still writing?
Me.
Okay. We got another minute and a half. I'm gonna shoot you.
I giant pit hat.
What is that? Everybody needs to be quiet.
Decision. Although they can also send a case back down to the lower court for another decision, which is called a remand. Although, you might call it a punt. Like 30 yards. The Chief Justice presides over the conference and assigns the task of writing the court's decision, called the majority opinion. The opinions are given in writing, although sometimes justices will read them from the bench. Sometimes the court will issue a single majority opinion, which is a very strong statement of unified agreement. In the key civil rights case of Brown versus Board of Education, the court issued a single opinion that was even stronger because it was unanimous. But sometimes the court will issue multiple opinions on the same case. The decision of the court, either to affirm or overturn the lower court's ruling, is called the holding. And this is the first thing you need to know in any Supreme Court decision. The second thing that matters is the legal reasoning or rationale behind the holding. If a justice agrees with the holding in the majority opinion, but for different legal reasons, they write a concurring opinion. The rationale in this concurrence is cool and everything, but the lower courts do not need to follow it. Only the holding of the majority and its rationale are binding on lower courts. A single justice writes a concurrence, but other justices can sign on to it if they agree with its logic. For instance, the eagle and I both agree that fish are delicious, but I would write a concurrence that the scales in the eyeballs are gross. It's unlikely this would go to the Supreme Court, though. Let's solve it now. Problem solved. Many Supreme Court cases are not unanimous. In fact, in an ideologically divided court, you are likely to find a lot of cases decided by 5-4 margins. The judges who are on the losing side, who didn't support the majority decision, can write a dissenting opinion. A dissent does not set a precedent for a lower court and has no force of law. But often dissents are very eloquent and they can provide arguments that might persuade later courts in similar decisions.
Got it.
It's very important that y'all know what a dissent is.
Did you say Senate?
Just
dissent.
in it.
A dissent. A dissent does not set a precedent for a lower court. It has no force of law. But often dissents are very eloquent and they can provide arguments that might persuade later courts in similar decisions. The case I'm about to tell you about is Brown versus Board of Education in Plessy versus Ferguson. At 9:42, we'll start the video again.
940 what?
9:42.
Oh, snap. Oh, that's right. Can you make it 9:44, please?
No.
You make it to the end of 9:42. Dang it.
Hey, Jill, I took a picture of it.
Can I see the picture?
Sometimes Sometimes, as with the famously bad case of Plessy versus Ferguson, the arguments in a dissent can form the foundation for the majority opinion in a later case, even though it can take 50 years to get from a case like Plessy to Brown versus Board of Education. So that's the nuts and bolts of how Supreme Court decisions are made. But before we wrap this up, here are a few key things to remember. First, there are a lot of hurdles you need to jump over before a court makes a decision in a case. Most certiorari petitions, there are usually about 8,000 each year, don't make it past the clerks or the Solicitor General, and don't get granted. It takes 4 judges to agree to hear a case, but 5 to render a majority opinion. Only the holding and the rationale supported by at least 5 of the 9 justices becomes binding precedent for lower courts. Dissents and concurrences may be fun and interesting to read, especially if there are pictures, and they may include important legal ideas, but lower courts don't need to follow them. So that's how the court works procedurally, but there's another way to think about Supreme Court decision-making. To really understand the Supreme Court, we need to consider the thinking behind judicial decisions. But that's for another episode. Thanks for watching. Crash Course Government and Politics is produced in association with PBS Digital Studios. Support for Crash Course U.S. Government comes from Vocal. Vocal supports nonprofits that use technology and media to advance social...
Okay.
I'm gonna write that. I got it.
Yeah, I hope y'all learned a lot from the video. Because like you said, all that's going to be on the quiz. They're going to take it in class. Okay? Let's see. Okay, now class, what I want y'all to do is I want y'all to get your iPads out, and I want y'all to go to this website for me. This website's called streetlaw.org. If you don't want any trouble finding it, the key is to type in everything that's on there. A lot of people just been typing in streetlaw.org and that's it, but you need to type in everything. You need to type in www.streetlaw.org/en/landmark/home, and it'll bring you right to this page. Okay? I'm going to explain what we're going to do here. Today, we're going to just get established with knowing what famous cases are. Okay? We're going to get established and figure out what famous cases are. Eventually, when I teach, this is what we're going to do. We're going to debate eventually with your class members. What you're going to, like the next class I'll probably do, we'll probably end up having some of y'all be Supreme Court justices, and then having some of y'all be petitioners, and having some of y'all be respondents and arguing cases against one another, okay? But for now, we just want to get established with what cases are, okay? And we're going to get familiar with famous Supreme Court cases. So all I'm going to have y'all do today is y'all going to pick a Supreme Court case, a famous Supreme Court case, and you're just going to simply write 5 facts about that case. That way, it's your choice what case you choose, and you're just going to write just simply 5 facts about the case. You can pick one of the 4 cases that are up here, or you can go over to the right-hand corner over here, where we have Brown versus Board of Education, Dred Scott case, Gibbons versus Ogden, Gideon versus Wainwright, Mapp versus Ohio, Marbury versus Madison, Miranda versus Arizona, McCullough versus Maryland. There are so many cases, Plessy versus Ferguson, and on and on. It was Roe v. Wade right there. There's a whole bunch of cases that you can do.
What's New Jersey v. What's that? What's those verses?
Well, you can look on there and find it. You know, if you got your iPad right there, it's up to you. You don't have your iPad. Oh yeah, it should be in the book. It should be in the book. Just go to the glossary and find a famous case. Who doesn't have an iPad? Nobody else has one. It's a little bit hard to do if you don't have your iPad. And you can pick the case you want to pick, but I want to make sure that everybody does this. Everybody look up at me. Listen close. Make sure you put the name of the case on your sheet. So if you write 5 facts and don't tell me what the case is, how am I supposed to know what case you're writing about if you don't tell me what the case is? So please write the name of the case on top of your sheet.
Somebody wants to know their name.
What?
Hey, come here.
to do 5 facts. Like, to give y'all an idea of what a good fact is, okay, you got Marbury versus Madison right there, right? Let's see, that's Marbury versus Madison. This case was done in 1803, okay? This case also established judicial review, right? That's how you list good facts. Because I don't just want just 5 plain sentences, I want 5 good facts too, you know what I mean? Like y'all would do for Coach Hunt. Because you know who's going to get to look at this? Coach Hunt. What does Coach Hunt want to see? He wants to see quality. And what happens if he don't see quality?
Here. He gives you a 0. This is quality, I know.
Oh, everybody knows she's playing. What's your name? Austin. Yeah. I want to demonstrate what Coach Hunt does when he doesn't see good material.
You
Yeah, I
basically
took a blank piece of
You basically cheat. Yeah, cheat from
That's a blank sheet. I asked you for a blank sheet. So. We don't want to see Coach Hunt do that with these papers, okay? So try to write decent, good facts. All you gotta do is just write 5 of them. You know, I could ask y'all to write 10, but 5 I think pretty fair. I think 5's fair. Don't y'all think 5's fair?
Yeah. I think it's 3.
Okay, so y'all wanna do 10?
No,
Y'all wanna do 10? Y'all wanna do 10 facts? Okay, whoever wants to do 3, that's gonna be 10 in actuality. Because what I'm gonna do is I'm gonna turn that 3 into like why, when, where, how.
But 3 times 5 is 15.
But see, what I can do, like I can have you write 3 questions, but what I would do, I would just add on each one of the questions. You get what I'm saying? Like I can have you write, okay, what is Marbury versus Madison? Why is it important? Okay, what did it say? What president did it say? Like who was involved? I can put all that on number 1. Would that be? How would you like writing 3 then? Do you want to write 3 then? You want to write 3 then?
I get it now. 3 facts with 5 things on each fact.
Exactly.
That's y'all are.
Y'all, who wants to do 3 now?
I'm good.
Who wants to do 3?
You doing more? Who said? TJ and Logan.
Y'all want to do 3? Y'all can do 3 that way. But you gotta give me why, when, where, how, on all of it. You're gonna end up writing 15 in the end. So just write 5 facts. Believe me, taking the easy way out only hurts you in the long run. You know, if everybody took the easy way out, this country wouldn't even be here. You know, this country was founded by people who did things the hard way. Not because it was the easy way, but because it was the right thing to do. Yes. Get a piece of paper. Will somebody loan him a piece of paper? Okay. Remember, if you can always hit read more, and it's going to tell you more detail about the case. Because like I said, eventually we're going to pick some of these cases. We're going to argue about some of these cases. Some of y'all going to get to be petitioners, arguing for your case. 5 facts. We give you 5 facts. When we do that, I think y'all would like that. But I got to give y'all just one good formal assessment that's not collaborative. So this is going to be it. Collaborative means y'all get to work together. Now, this activity y'all want to work by yourself, but eventually, because I'm going to teach at least 3 more times. So eventually, the rest of the activities are probably going to be more collaborative. But I got to do at least one formative. Yeah, my video still rolling. That's good. Yeah. Anybody gonna run to the restroom again?
Okay, you want to pause it?
No, I don't need to pause it. You can just keep running.
Are these fake names? Some of these are fake names. They have to be. Look at the names.
Anybody done with your 5 facts? If you're done, you go ahead and turn it in. Just raise your hand and I'll
Is
take
it a
it.
name?
You done with your 5? Interesting. It's probably, I'm not actually sure. You may want to look that up. I'm not actually sure on that. Yeah. Yeah, that baby probably was already born by the time that case got decided, though. Yes.
You said, they started in 2000.
Yeah, that case started in 2000.
What did?
You put the candles as a fact on that right there. I said, another fact you put for that is like the candles, like you can listen to the candles work. Whenever you get done, just raise your hand, let me know. Or you can turn it in up here. You turn it in. Huh? Oh, they got 10 oh, shut it. I swear I need 5 more minutes to add to every class, I swear. Okay, who's all done with their quiz? Who's all done with their entries? I'm going fast out the quiz. Quiz is not hard, it ain't hard. Write on your own sheet of paper, it's not hard at all. It's not hard. It's easy. It's not hard. Every time I do quiz, I just automatically think it's going to be just so difficult. Who's all done? Please write on your own sheet of paper, please. You done, you done, sure? Huh? Oh. Okay. Yeah. We're going to do a quiz, okay? Right on your sheet of paper. Who needs a quiz? No, you gotta use your notes. You should be able to remember. It's not, trust, it's not that hard. It's not that hard at all. All you gotta do is just write the answers. Just write down the answers. You got any quiz? Any quiz over there? Quiz. Yeah, at the top of the paper, write down quiz the federal court system. So I know which quiz I gave you. The federal court system. In fact, I'll write it up here. Let me get done with the quiz later right here. I don't think that quiz was too hard, was it?
Yes, it was. I finished it actually. I kind of think that.
I don't think that quiz was hard at all.
I just don't know what the words. It's like really good. Oh, I just kicked my
Because my main thing, I want y'all to gain knowledge. I want y'all to learn something. If I can teach y'all just one thing a day, I'll be happy. Because you come to school to learn, not just to get busy work, or not just to goof and play around, you come to learn. The more you learn, the better off you are. That's my philosophy of teaching. You could easily just walk out to sea. lay it back there. Remember what started with 2 years ago? Which would be quiz in. Anybody else need a quiz? Or turn it over here? Any quiz? Just write down the answer, please. Write down the answer. That's right here. We're going to start with the quiz, like you got like 20 minutes. I'll probably come up with a different lesson for tomorrow. Just in case he doesn't come back. So I don't know. You may be back tomorrow. I don't know. I'm not sure. Just go ahead and steady. Be looking at chapter 8, unit 2. That'll probably be the lesson I do. Chapter 8, unit 2. That'll be the next section. Okay? Just go ahead and try to go ahead and do that. Kind of work. You got 3 more. All right. Okay, everybody, in the bell ring, everybody take your seat. I'm gonna go over it real fast, okay? We got one more. I think there's one more.
I'm about to go on and answer.
Okay, everybody listen up. Listen up. Okay. For judges to actually hear the case called blank, 4 of the 9 justices have to agree to it. What is that called? What was the answer? B was the answer. Grand service for areas. That's hard. How many federal jurisdictions? How many federal jurisdictions? 12, that's correct. How many judges on the Supreme Court?
9.
Correct. If 4 of the 9 justices decided to hear a case, the petitioner and the other side was against, the respondent must submit a what?
C.
Briefs, correct. In order for a decision to be offensively rendered blank, which is a simple majority, what's the side on? What is it, 5 or 4? 5, correct. Yeah, number 5 was 4. Well, no, 5 was 5. The number 6 was A, Chief Justice. And number 7 was the 6, which is B.
Your leg's fast.
You turn it.
Thank